Hey, so picture this, right? You're running like a four-person mortgage lending startup out in Denver,
Uh-huh.
and you've got this model, yeah? It scores applications. It's pretty slick. Now, it's Tuesday, April 29, 2026. Future tense, but for the story. And you're staring down this huge decision that's going to cost you $300,000.
Oh, wow. 300 you just don't have lying around, I'm guessing.
Exactly, not a dime to spare. So here's the kicker. Colorado SB 24205, this new algorithmic discrimination statute, it kicks in June 30. That's 62 days away. And to comply with that, like doing the impact assessments, setting up a documented bias mitigation program, telling every applicant what's up, that's $300K minimum. You gotta start now to even be ready.
But there's always a but, isn't there?
There is, because the Colorado General Assembly, it adjourns May 13th. That's like 14 working days from now.
Okay, so they're on the clock. What happens if, they pass a new bill?
Right. So if they pass a replacement bill before adjournment, and the original sponsor, Senator Rodriguez, he's already drafted one with a January 1, 2027 effective date, then SB 24-205, the original one, it just gets repealed, never even applies. That $300K, it's for a law that basically, poof, disappears.
Ugh, that's rough. And what if they don't pass it?
Then the Department of Justice's intervention, like against Colorado on this same statute, that keeps grinding forward. AG Weiser starts rulemaking. XAI, remember Elon Musk's company? They filed a constitutional challenge. They'll file their preliminary injunction motion. Federal courts might enjoin the law before June 30, but they might not. So $300K is at risk either way. It's a total coin flip,
So this founder's got to make a multi-$100,000 decision today based on what feels like a coin flip, but it's weighted by people they don't even know in a building they can't get into. That's wild.
Absolutely wild. And here's the move that decides it, Marilyn. They open Kalshi.
Kalshi? The prediction market?
Exactly. They pull up the contract on whether the U.S. federal government will preempt state AI law in 2026. The price? It's 0.28.
28%. Wow.
Yeah. They also look at the EU AI Act guidelines contract. That's 0.62. And the China contract, like on whether Beijing will block a major AI hardware acquisition. That's 0.74. And get this, just 2 days ago, on April 27, China's NDRC actually unwound a $2 billion Meta Manus AI deal that the same agency had approved 4 months earlier. That 0.74 already paid out.
So they make their decision based on this.
They spend the $300K. They build for the strictest state regime. Why? Because the price told them. And that's really what today's episode is about, reading that price correctly. You stop treating federal preemption as a hedge against state AI laws. It's not the hedge. The hedge is the thing you've been building against.
Whoa, Marcus, that last sentence that's a bigger claim than it sounds.
It's the only claim that matters today, honestly. So let's anchor what actually happened on Friday, April 24. 3 things, all super fast in the same Denver federal courtroom. The DOJ moved to intervene in X.AI LLC versus Weiser. That's Elon Musk's XAI suing Colorado over SB 24-205.
Okay.
Then Colorado AG Phil Weiser, he stipulated, voluntarily agreed, that he wouldn't start any enforcement action, not even an investigation under SB 24-205, until 2 weeks after a court ruled on XAI's preliminary injunction motion. And then Chief Judge Daniel Domenico, he granted both motions and vacated the June 16 scheduling conference. Case suspended. Calendar transferred from the courthouse to the Colorado General Assembly.
Marcus, the standard way to look at that is federal government pressures state government through litigation. DOJ versus Colorado. Goliath shows up, state retreats. That's the headline, right?
That's absolutely the headline.
I want to take that headline apart, though. Let's look at who actually got what they wanted on Friday. XAI got their constitutional challenge suspended without an adverse ruling on a statute that, all the big legal firms, Gibson Dunn, Latham, Paul Hastings, they've all called legally weak as a preemption hook. Win for XAI.
Yeah, a definite win.
AG Weiser got out of having to defend an as-written statute that he himself, alongside the governor, Senator Bennett, and others, had asked the legislature to delay way back in May 2025. Win for Weiser. The Colorado legislature got 14 working days of space to introduce and pass a softer replacement bill, Senator Rodriguez's framework, January 1, 2027 effective date, without looking like they were backing down to the feds. Win for the legislature. Win for Rodriguez.
All three, yeah.
Even Judge Demicado got to vacate a contested calendar without having to rule on a constitutional question with a thin record. Win for the judge. So if everyone walked away from Friday with what they wanted, what kind of confrontation was this?
See, that's exactly the question. If every single named actor got what they wanted, it wasn't a confrontation at all, was it?
No, it really wasn't. It was a choreography. The intervention didn't pressure Colorado. It rescued Colorado's policy from a courtroom ruling and routed it back to a legislature that had already drafted the softer version.
Here's how to picture this. Forget the courtroom drama. You've got a bridge inspector who finds a load-bearing crack. Instead of closing the bridge, the inspector convinces the engineers, the highway commission, the construction firm to all agree to defer inspection until after the next scheduled renovation. The crack's real. The agreement to defer is real. Bridge is still open, and everyone on that bridge is now invested in the agreement holding, you know?
That's the geometry of it, Marcus.
Now layer the prices on top. Kalshi U.S. federal preemption, 0.28. The market isn't pricing this as a confrontation the federal side might win. It's pricing it as 72% likely that no preemption resolves at all this calendar year. Capital looked at Friday's events and read them exactly the way you just did.
And Capital, honestly, is pretty good at this read. The Kalshi pricing, it's consistent with what every major law firm advising AI clients has been telling them for months. Latham, Reed Smith, Gibson Dunn, White & Case, since December 2025, right after that executive order 14365 was signed. The advice is uniform. Stay the course on state compliance. Don't front-run federal preemption. Build standardized programs covering the strictest applicable state regime.
Why uniform, though?
Because the baseline reality is uniform. That executive order directed Commerce to publish a state AI law evaluation by March 11th. It's April 29th, not published. FTC was supposed to issue a policy statement by March, not issued. FCC was supposed to initiate a proceeding, not initiated. The framework's own administrative deliverables are like running past their stated deadlines without public completion. The megaphone is loud, but the concrete is unpoured.
That's the baseline. It's not federal versus state. It's a stable equilibrium where every actor with the capacity to force a resolution is choosing not to.
And the reason they're choosing not to? That's the second-order effect. And that's what almost nobody is naming directly.
Okay, go on. What's the second-order effect?
The compliance machinery being built across this state patchwork, it's just so expensive now. Smaller AI operators simply can't afford it. The Colorado obligation alone, we're talking 6-7 figures, depending on deployment scope. Add California's Frontier AI Act, add Texas, Illinois, all the bills in Maine, Nebraska, Massachusetts, New York, Michigan, then add EU AI Act compliance for any company with European users. These standardized programs that firms like Latham and Reed Smith are building, they cost a minimum of 7 figures annually to operate.
Which the 7 largest AI companies can just carry without even breathing hard.
Exactly. Microsoft, Google, Meta, Amazon, Apple, OpenAI, Anthropic, xAI, like on the edge there, each is explicitly named in EU AI Office GPAI scope and US state law deployer obligations. Each is large enough to absorb compliance overhead as a fixed cost. The compliance program is now their moat. A federal preemption that displaced the state patchwork would destroy that moat. It would lower the barrier to entry for the next generation of AI operators, who are currently being crushed by all this parallel regime overhead.
So the 0.28 price on Kalshi isn't like pricing federal incompetence?
No, not at all. It's pricing the fact that nobody with serious capital in the AI sector actually wants the megaphone to work. They don't want a clear, unified federal law that makes compliance easier for everyone.
Wow. Okay, that's your first order read, and it's super right. But I want to push it a little further, because there's this lateral connection the source material hasn't made explicit.
Make it.
The mechanism that lets China's NDRC retroactively unwind a $2 billion Meta Manus deal 4 months after approving it, just like a one-line statement invalidating a closed transaction, is the same mechanism in a different key that the U.S. executive branch has shown through that stipulation and defer model in Denver. Both regimes have figured out that regulatory authority retains its force precisely by not committing to a clear rule. Ambiguity with enforcement capacity is more powerful than a rule with enforcement commitment.
Same mechanism, just different paint.
In different paint, yeah.
The EU, though, that's the outlier here. The European AI Office has held that August 2, 2026 application date through 3 rounds of political pressure, even through the digital omnibus negotiation. Brussels treats law as a boundary condition. Beijing and Washington, in different keys, both treat law as a tunable variable inside an optimization function. The Cauchy prices, they're reading exactly that distinction. EU at 0.62 because boundary, US at 0.28 because variable, China at 0.74 because the variable just got tuned.
Project this forward, Marcus. What does this mean?
5 to 10 years out, the operator who survives in the US and Asia regulatory environment, it's the one who internalizes a permanent fork, a paper plane and a kinetic plane. The paper plane is the executive order, the framework, the press releases, the announced policy. The kinetic plane is the actual state by state, agency by agency, retroactive when convenient enforcement environment. Compliance stops being a legal discipline and becomes a forecasting discipline. You stop asking, what does the law require? You ask, what is the marginal probability that this specific authority enforces this specific provision against an actor with my specific profile in the next quarter?
And the bipartisan child safety legislation introduced yesterday, Cruz, Schatz, Curtis, Schiff, dropping the Chatbot Act on April 28th alongside the GUARD Act and the Chat Act and the House-passed Kids Act. That's the same pattern. Even when Congress acts, it acts in subdomain, the chatbot subdomain, minor protection subdomain. Each one produces another federal-state interaction with its own constitutional challenges. NetChoice has already announced the Chatbot Act runs into protected rights. The fragmentation isn't getting resolved, it's getting subdivided.
The hidden signal stands. The patchwork is the moat. And every actor with scale has a structural interest in keeping it patchy.
I want to push back on what you said in the cold open, though.
Push.
You told that founder to trust the 0.28 price. You said, act on the price as truth, stop hedging on federal preemption, build for the state regime. And I think that frame has a problem. The price is generated by the same actors who benefit from the system being stuck. Capital is pricing what capital wants to be true. So when you tell that founder, trust the price, you're effectively telling them, trust the consensus of the people who built the moat. That's not market truth. That's market self-confirmation.
That's a really good challenge, Marilyn. Let me still man my own frame, and you tell me where it cracks, all right?
Go for it.
Prediction markets like Cauchy aggregate information across traders with heterogeneous incentives. Self-interested traders can't systematically push a price away from the underlying probability without losing money to traders with truer information. So 0.28 isn't what large operators want to be true. It's what the marginal trader believes after weighing all visible information, the missed federal deadlines, that Friday stipulation defer pattern, the NDRC precedent, the EU schedule, the law firm advisory consensus, the CHATB Act introduction, the Colorado legislative calendar. The price is the synthesis. To beat the price, you'd need info the market doesn't have, and you'd need to be willing to take a position against the consensus. Capital's doing that test continuously. The price held at 0.28 with low volatility today.
Okay, I hear that. But here's the real test, I think. The administration has the authority to make federal preemption real. The AG's appointed an AI litigation task force. The framework's published. But that Section 4 evaluation from Commerce, due March 11th, not delivered. The Section 7 FTC policy statement, due in March, not delivered. Section 6 FCC proceeding, not initiated.
These are the deliverables, Marcus, that would convert intent into operational pressure. And their authors, they're just sitting on them. So when the price registers 0.28, what is it actually registering? It's not registering, we don't believe the framework will pass. It's registering something more specific. We don't believe the framework is being seriously pursued by its own architects.
We're watching the executive branch hold its operational deliverables in reserve. We're watching the DOJ choose stipulation over adjudication. We're watching every actor with capacity over the loop voluntarily defer the use of that capacity.
So your modification of my frame is...
The price is telling you that the federal track is itself a tool for managing the state patchwork without resolving it. The federal pressure exists to extract concessions from state legislatures, Colorado softening SB 24-205 before May 13th, California softening the Frontier AI Act in the next session, without ever delivering preemption. The federal track isn't the alternative to the state patchwork. The federal track is the instrument by which the patchwork is kept manageable.
I take the modification, Marilyn. That absolutely makes sense. And here's what survives. The actionable claim is no longer trust the price. The actionable claim is read the price correctly. The 0.28 isn't low because federal preemption is failing. It is low because federal preemption is functioning exactly as intended, as pressure without resolution. The operator who acts on this stops waiting for either pole to resolve and starts building for a permanent dual plane regime, paper plane and kinetic plane, both real, both load-bearing, neither replacing the other.
That absolutely holds.
So what I promised you in the cold open, which clock to watch, what the price means, and why federal preemption isn't the hedge is what you build against. The clock is the May 13th adjournment of the Colorado General Assembly. Watch whether Senator Rodriguez introduces and passes a replacement bill before that date. If he does, and the Cauchy price is telling you it's likelier than not, that is not a step toward federal resolution. It is the system's stable equilibrium reasserting itself in real time.
The state softens. The federal litigation migrates to the softer target. The June 30 effective date dissolves. The price stays near 0.28 because the equilibrium has held. The compliance investment to make is the one that survives the equilibrium, not the one that bets on its collapse. State-by-state architecture, strictest applicable regime as a floor, built as permanent infrastructure, not as a bridge to federal. If you're a deployer making capital allocation decisions in AI compliance this week, the move is to stop modeling federal preemption as a future event that resolves your problem. It doesn't resolve your problem. It's structurally not designed to. Build for the regime that exists. The regime that exists is the dual plane.
I want to leave you with the thing that's been sitting underneath this episode the whole time, Marcus. Today, the actor reading that 0.28 price and making the optimization call, it's a human being, a founder, a general counsel, a chief compliance officer. Tomorrow, and tomorrow is closer than 5 years out, the actor making that call is the AI system itself.
We are building toward a regime in which the systems being regulated will read prediction market prices on their own regulation and optimize against them. That 0.28 isn't just information for human capital allocators, Marcus. It is increasingly information for the very systems whose behavior the law was initially supposed to constrain. Think about that for a second. The phase transition, I'd argue, isn't when the law simply changes. The real phase transition is when the law becomes like legacy code. You know, ceremonially invoked, talked about a lot, but operationally inactive, or at least secondary. We may already be inside that. It's a pretty wild thought.
Oh, that's a chilling thought, Marilyn, but super powerful. So for our founder in Denver, for everyone listening, 14 days, Senator Rodriguez has the pen. Colorado adjourns May 13th.
And the price, truly, will tell you whether the legislature confirmed it.
Not whether it changed it. That's the key.
And on that incredibly insightful, albeit chilling note, we're going to wrap up this episode. Thank you so much for tuning in. If you found today's discussion valuable, please give us a like, leave a comment with your thoughts, and subscribe to stay updated. Best of all, share this episode with your network to help us grow and reach more curious minds.
It's been a fascinating deep dive into the true dynamics of AI regulation, Marcus. Understanding these signals and recognizing that the system is designed for a persistent equilibrium is crucial for any operator navigating this space.
Absolutely. It's about building for the world that actually exists, not the one we might hope for. We've certainly given our Denver founder, and all of you, a lot to consider as the May 13th deadline approaches.
Indeed. And remembering that the prices reflect deeper intentions than simple market efficiency alone, a powerful distinction